Hello, good morning. Yes, this is Group 2. We're about to report the Chapter 8, Mandatory and Directory Statutes. Mr. Carator will be in charge for the introduction. Mr. Washington Dabu will be the charge for the mandatory. And I'm yours truly in charge of Directory Statutes. Of course, I will go directly to my topic. I let the two handsome boys to discuss their topic assigned. Directory statutes. Statutes prescribing guidance for officers. It's a regulation designed to secure order, system, and dispatch in proceedings, and by a disregard of which the rights of parties interested may not be injuriously affected. Exceptions, unless accompanied by negative words, importing that the acts required shall not be done in any other manner or time than that designated. Statutes prescribing manner of judicial action. It's construed directory. Procedure is secondary in importance to substantive right. Generally, non-compliance therewith is not necessary to the validity of the proceedings. Statutes requiring rendition of decision within prescribed period, like Section 15, Paragraph 1 of Article 8 of 1987 Constitution, the maximum period within which a case or matter shall be decided or resolved from the date of its submission shall be 24 months in the Supreme Court, 12 months in the lower collegiate courts, 3 months or other lower courts. Also in Section 7, Article 9, Paragraph A, 1987 Constitution, 60 days from the date of its submission for resolution for all the Constitutional Commission. Before the Constitution took effect, statutes requiring rendition of decision within prescribed period. Except intention to the contrary is manifest, the time is of the essence of the thing to be done, language of the statute contains negative words, designation of the time was intended as a limitation of power, authority, or right. Always look at intent to ascertain whether to give the statute a mandatory or directory construction. The basis, expediency, lest injury result to the general public by disregarding that enforcing the letter of the law and that judges would otherwise abstain from rendering decisions after the period to render them had lapsed because they lacked jurisdiction to do so. Constitutional Time Provision Directory. What's the reason? Statutory provisions which may be thus departed from with impunity without affecting the validity of statutory proceedings are usually those which relate to the mode of time of doing that which is essential to effect the aim and purpose of the legislature or some incident of the essential act. Liberal construction, departure from strict compliance, would result in less injury to the general public than would its strict application. Courts are not divested of their jurisdiction for failure to decide a case within the 90-day period. Only for the guidance of the judges manning our courts. Failure to observe said rule constitute a ground for administration or sanction against the defaulting judge. A certification to this effect is required before judges are allowed to draw their salaries. The case, GR number L 42428, March 18, 1983, Bernardino Marcelino, the petitioner, versus Honorable Fernando Cruz Jr. as presiding judge of Branch 12 of the Court of First Instance of Rizal, People of the Philippines, and the Provincial Warden of the Provincial Jail of Rizal, the respondents. A petition for prohibition of writ of habeas corpus to enjoin respondent Judge Fernando Cruz from promulgating his decision in criminal case 5910, entitled People of the Philippines versus Bernardo Marcelino, and for release from detention of petitioner, the accused in said case, on the ground of loss of jurisdiction of respondent. trial court over the case or failure to decide the same within the period of 90 days from submission. Petitioner was charged with the crime of rape. The attorneys for both parties moved for time within which to submit their respective memoranda. Counsel for petitioner submitted his memorandum in due time, but no memorandum was filed by the people. November 28, 1975, respondent judge filed with the deputy clerk of the court his decision in said case for promulgation. On the said date, promulgation for the decision, counsel for accused moved for postponement, raising for the first time the alleged loss of jurisdiction of the trial court for failure to decide the case within 90 days from the submission thereof. What is the issues? Petitioner posted that the 3-month period prescribed by the Section 11, Article 10 of the 1973 Philippine Constitution, being a constitutional directive, is mandatory in character, and that non-observance thereof results in the loss of jurisdiction of the court over the unresolved case. Ruling, the court disagree. Undisputed is the fact that November 28, 1975, or 85 days from September 4, 1975, the date the case was deemed submitted for decision by the respondent judge, filed with the deputy clerk of the court of that criminal case. There is no doubt that the constitutional provision cited by petitioner refers to the rendition of the judgment and not to the promulgation thereof. Wherefore, the petition is hereby dismissed, and the restraining order dated January 16, 1976, issued by the court is lifted. Since respondent Judge Fernando Cruz Jr. is already deceased, his successor is hereby ordered to decide criminal case, the basis of the record thereof, within 90 days from the time the case is referred to him. What is the principles? Section 11, Paragraph 1, upon the effectivity of the Constitution, the maximum period within which a case matter shall be decided or resolved on the date of its submission shall be 18 months of the Supreme Court, and unless reduced by the Supreme Court, 12 months for the inferior collegiate courts, and 3 months for all other inferior courts. Constitutional provisions are to be construed as mandatory, unless by exhaustion or by necessary implication of the different intention is manifest. Well, that is the end of our report for the Group 2 Mandatory and Directory Statutes. On behalf of my co-reporters, Mr. Carator, Mr. Dabo, I'm yours truly, Ms. BLANCO-AÑONUEVO, for the reporting for the class of Statutory Construction, November 10, 2022. Thank you.